I was questioning a doctor in a medical malpractice deposition. And now what should have been an hour-and-a-half long question and answer session turned out to be 5.5 hours long, all because of what the doctor did. Would you like to know the answer of what he did that prompted me to get so frustrated and so upset with the doctor? And the nonsense that he did? Come join me as I share with you the answer to that question in this very unusual neighborhood I'm shooting video in today. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. I'm going to give you a quick look around to see where I'm shooting video, and I want you to try and guess where I am shooting video. There's some beautiful white structures behind me. As I turn around this way, you're going to see the ocean behind me, some beautiful boats, and there's even mountains all the way in the back. All right, so let's get right to it. This was a medical malpractice case, and now this was the first doctor out of a few that I had the ability to question. And what should have been a very straightforward, simple question and answer session under oath turned out to be a very frustrating, very aggravating deposition. Why? The key reason is that the doctor refused to answer my questions, and he refused to answer them in a very simple, straightforward manner. You see, when I question a doctor in a medical malpractice case, I find that my questions tend to be very simple, very straightforward, and most of them call for simple yes or no answers. I'm not there to trick the doctor. I'm not there to try and pull the wool over his eyes. I need certain information from the doctor, and I need him to tell me whether he did something or didn't. Does he agree with my statement or doesn't he? There are times when I will ask him to explain certain things. Doctor, do you have an opinion with a reasonable degree of medical certainty as to whether or not the failure to do X, Y, and Z represents a departure from the standard of care? Yes, I do. All right, doctor, what is your opinion? And now he can go ahead and explain. Now, in this particular case, I will ask the doctor specific, straightforward questions. Doctor, you wrote a note for this patient. Is that true? Yes. In fact, you countersigned a note written by the physician's assistant. Isn't that true? Yes. And your note was countersigned 2 days after this patient was seen in the hospital. Isn't that true? Yes. Now, this is the only note that I'm questioning the doctor about. It's a very short note. And the note that he countersigned involved a physician's assistant who saw and evaluated and treated my client. You would think that this would be so simple. There's not a lot to cover here. But I needed to ask the doctor specific questions about what he observed, what he did, the purpose of countersigning a note, and what his role and responsibility is as an attending physician, now supervising this physician's assistant. Now, when I would ask the doctor a very simple, straightforward question, the whole goal is to get him to acknowledge and to admit what is in his note and what is not in his note. The doctor, instead of responding to my questions, would tend to go on and give long-winded explanations, having nothing whatsoever to do with the question that I asked. So let me give you an example. I would ask him, Doctor, isn't it true that you make no mention in your note that you wrote that you personally observed a hemorrhage? Isn't that true? And rather than simply saying yes and acknowledging that there's nothing in his note to reflect that he personally observed a hemorrhage in my client, you know what he said? He said, well, I noted, based upon what the physician's assistant wrote, that he had the following symptoms and that he had the following findings on examination, and he had this observation, and this, and this, and this. Doctor, did I ask you to explain any of that? I just want to know, based upon your note, whether or not you personally made an observation that's contained in your note to reflect that you observed a hemorrhage. And this is how he answered. And for 30 to 45 seconds, he was just contemplating in his own mind how to answer my question so that it didn't look as if he was liable or responsible for causing my client's injuries. It was fascinating. And this went on many, many times. He would stop and he would contemplate and he'd be thinking. And now I know for certain that his attorney would tell him, prior to my questioning, would tell him, listen, you take all the time you need because there's no way for anyone who reads the transcript of the questions that you're being asked and the answers that you give, there is no way for anyone to know how long it took you to actually answer the question. And he's right. Someone reading a transcript at trial is never going to know that the doctor took 35 to 45 seconds or 60 seconds to answer a question. But it's like when you're having a conversation with someone and you ask a question, they immediately respond. You know, and I know, that this doctor is trying to come up with some concocted story about why he doesn't have these observations written in his note. And this went on over and over again to the point where I turned to the doctor and I said, you know what? Is there some part of my question you really did not understand? I asked a simple yes or no question. Doctor, can you point to me where in your note you indicate that you observed a hemorrhage? And he would do one of these head tilts, like when you ask a dog a question that the dog doesn't understand, and he'd do one of these. And I said, do you not understand my question? Show me where in your note it reflects that you observed this patient had a hemorrhage. And instead of answering my question about showing me, he would go on and on, talk about something I didn't ask. And I would say, Doctor, did I ask you about that? Why did you answer and give me an explanation? He said, well, I wanted you to understand. I said, Doctor, if I want to understand, I will ask you to explain. I don't need an explanation. I just need to know from you whether or not you observed X, Y, and Z. And again, he went off and started explaining without me asking. And again, I'd have to go back and circle back and say, Doctor, your attorney can ask you any questions he wants when I'm done. He can ask you to explain things away if I have not done so. So, my question focuses on something that's very simple. It's either yes or no, or I don't know or I don't recall. All right? Have you understood that? Yes. All right. So then I would ask another straightforward question that called for a yes or no answer. And again, instead of giving me a yes or no answer, he'd go off and give me a long-winded explanation. Now, how does this apply at trial? And why is this information that I'm discussing with you, why or how can I use this at trial to our benefit? I'll tell you how. At trial, if the doctor were to pull this nonsense, I guarantee you that the jury would see right through him and they would not appreciate his antics trying to avoid answering the question directly. And the way to do that at trial, and this is really, really useful, is to turn to the doctor at trial and say, Doctor, I'm going to be asking you a series of questions that call for a yes or no answer. If you can answer it yes or no, do you promise to answer it yes or no? The doctor has to say yes. Doctor, if I ask you a question and you do not understand it, do you promise to tell me that you do not understand the question? Yes, I do. Doctor, if I ask you a question to which you do not understand, and you tell me that you do not understand the question, I don't want you to answer the question. Is that agreed? Again, he's got to agree. And doctor, if you do not recall something, do you promise to tell me if you don't remember as I'm questioning you and asking you certain questions? You promise to tell me that and not give me a long-winded answer about how you might have known, you could have known, you should have known. I don't remember. That's fine. But you've got to tell me, correct? Yes. And if you don't remember, you promise to tell me that. Is that right? Yes. So now when the doctor is asked questions at trial, a simple yes or no answer, if the doctor does not go ahead and give a yes or no answer after he's already promised to do so, now he begins to look like he's hiding something. He begins to look as if there's something he's trying to avoid. He's trying to avoid giving the right answer. He's trying to avoid giving any answer, anything, just not to answer the question directly. And at that point, the jury will not appreciate those things. So the fact that the doctor went ahead and frustrated me and extended his pretrial deposition for literally 4 more hours than what it should have been shows me exactly the type of person he is, even though he may be smart medically, even though he may be a nice guy, even though he may have had years and years of experience. The problem with him is that doing that at trial will destroy his credibility. So why do I share this quick information with you in this beautiful location? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-4600. 8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.